Hello, everyone, and happy Wednesday. Welcome to another episode, the first episode of Women Winning Wednesdays of 2022. We made it. So it's wonderful to be with you again on another fantastic Wednesday. I've got more good content for you as I always try to provide to you. Just a bit of housekeeping. Those of you who follow me for a while know this, but if you'd like us to see your comments, please allow StreamYard for us to see your comments. Please go to facebook.com/StreamYard. And let's see. Where I'm really not had enough coffee, obviously. So today we're going to talk about the estate planning mistakes made by women and how to avoid them. Estate planning mistakes made by women and how to avoid them. Before I launch into the list, let me correct something I just said. You go to StreamYard.com/Facebook. I had it turned around, so sorry about that. StreamYard.com/Facebook in order for us to see your comments. Now, what I was going to say is that there's a quote that I want to share. It's a quote that really helped get us focused and ready to start the new year and to help us not beat ourselves up so much for what we wanted to get done but didn't in the prior year. And it reads as follows: forgive yourself for not knowing what you didn't know before you learned it. Forgive yourself for not knowing what you didn't know before you learned it. And that quote is from Maya Angelou. All right. So hopefully that sets the right tone for what we are going to talk about today, which are, again, estate planning mistakes made by women and, more importantly, how to avoid them. There are, for those of you who are taking notes, there are actually 17 of them. I originally started my list with 7, but found 10 others that I wanted to share. So they're all going to be shared with you here today. And by the way, this video will be available on replay. So if you don't get through the whole thing today, because you have to get back to work, you're driving, or what have you, this will be available on replay. So here we go. Number 1 is that you have no idea what your estate plan looks like. Now, many people put off estate planning because they assume that they don't own enough, they don't know enough, or they're too young, or they're too busy. Those are the 2 common ones I hear a lot. Some don't understand what an estate is. An estate includes a person's belongings, physical and, intangible assets, land, real estate, investments, collectibles, and furnishings. Those all comprise your estate. Number 2, realizing too late the need to protect your assets. Now, if you're getting married, for example, and you're bringing assets into the marriage, like an existing retirement savings account or a pension, you want to consider perhaps trusts that specifically state how you want your assets distributed upon your death, as well as dealing with the beneficiary designations in those respective vehicles, investment vehicles. And I'm going to get to that later on down in the list. But think about what you're both bringing into the marriage and, what happens in case you die. How are those assets going to be allocated? Number 3, thinking that unmarried or childless or child-free women don't need a will. And by the way, there is a difference between childless and child-free. And I want to challenge those of you who are watching to just look that up, because the difference is important, and certainly important among the many women that I've been honored to serve. So just a little side note there. So without a spouse or children, many unmarried women believe that they don't need a will because they don't have any heirs. However, these women still have, valued possessions that could be left to friends, unmarried partners, or charitable organizations, if they're specified in an estate plan. I've had clients who, just as an example, they belong to sororities, and they have precious memorabilia that they've collected over the years. Then there are those who have traveled extensively, one I'm thinking of right now, and had an extensive art collection. Now, without a written plan, in a will, what ultimately happens to those items will be left to a court and not you. In the absence of a will, distributing your assets becomes the responsibility of the state in which you reside, and that process is called probate. Number 4, not updating your child's guardianship plan, or not having one at all. No one likes to imagine someone else raising their children, but it's so important. It's crucial. You have to plan for the possibility, just in case. Without designating a guardian for minor children, there's no telling who, with absolute certainty, would get custody of your children if you were to pass away. What if you and your spouse pass away at the same time? Those things you need to keep in mind. The appointed guardian may be, in a divorce situation, the appointed guardian in your plan, if you have one, say maybe it's someone very close to your former spouse. And now, post-divorce, you may not feel comfortable with having that individual as a guardian or even as a successor guardian, right? So these are things that you need to take into consideration. Number 5, leaving advance directives undone. Whether you're a stay-at-home mom or in the workforce, or arguably, the women, certainly women who are stay-at-home moms, that's a job in and of itself. So whether you're not in the workforce or you're at home, disability insurance is important to protect your family if you're no longer able to work. And the stats show that over 50% of the population becomes disabled before they turn 65. Typically the older you are when you buy disability insurance, the more expensive it is. The younger and supposedly healthier you are when you buy disability insurance, the easier it is to qualify for a policy. Number 6, not having, I jumped ahead. Let me go back a second. This is one of those funny things, leaving advanced directives undone. Let's do a retake on that. Now, if you're having minor surgery, for example, or suffer from a debilitating medical condition, you need to have these advanced directives in place so you can direct who's making decisions for you. They can communicate how medical decisions should be made if you can't make your own decisions. And as I've covered in prior videos, the advanced directive in Maryland has two parts. The first part is where you designate your healthcare agent. The second part, which is optional, but it is known as a living will. And that's where you indicate what medical decisions you want made or not in three distinct end of life or near end of life scenarios. Now, we can properly talk about not having disability insurance. And let's go over that again, because that's important. Again, I just want to go over that stat. Over 50% of the population becomes disabled before they turned 65, according to this popular statistics. And again, the older you get, the older you are when you're purchasing disability insurance, it becomes a little trickier and certainly more expensive to get. So if it's something that is within your budget, by all means, please make that a priority. Now, moving right along to number 7. There are a lot to get through. Delaying creating a power of attorney. Now, if you become incapacitated, in other words, if you're unable to make decisions, a power of attorney is crucial. It's a document that gives your agent, that's the person you choose, the authority to enact financial and healthcare decisions on your behalf. Don't assume that if you get sick, your spouse will be able to get access to your bank account, for example. If he's not a joint owner, the bank is going to properly refuse his request to withdraw funds. So there's not much you can do at that point if you're in the hospital and have bills that need to be paid, and your separate account is where those funds are located. Okay. Number 8. And by the way, before I move on to number 8, if any of these are resonating with you, let me know. Let me know in the comments, because I know these are pretty common, and all of us, myself included, have been guilty of one or more of these. So no shame in admitting. Here, this is a safe space. Number 8. Neglecting to transfer real estate titles after a divorce. Now, let's say you've just married the love of your life, but he still owns property with his ex-wife. If he is either moved on from the property or he suddenly dies, you can only inherit his half. And then you're in a situation where you're dealing with the ex-wife, you're dealing with the former spouse. The ex-wife, I should say. And that's, among other things, awkward. But it's certainly a situation that is avoidable. So if you're in that situation or foresee that, make the title transfer, make those arrangements part of the divorce proceedings, just so that everything's cleaned up and you don't have any issues as you're going into your new marriage, your new chapter. All right. Number 9 of the mistakes commonly made by women. Not naming beneficiaries or listing them incorrectly. All right. Now, not designating a valid beneficiary or failing to remove one you no longer want can put assets in the wrong hands. And let me just pause here for a second, because a common mistake that I see among so many people, not just women, but particularly the women that I serve, they name their minor children as beneficiaries. Please, if you get nothing else from this video, please do not name minor children as beneficiaries on your accounts. They don't have the legal capacity to inherit those funds. What's going to happen is, if there's not a guardian in place, you're going to have to go to the surviving spouse is going to have to let me backtrack for a second. That child is not legally able to accept those funds. So you're going to have to go to court, name a guardian to guard those funds, to manage those funds until that child is of age. So unless those funds are going to a trust account, which we will talk about later on the list, you don't want to do that. You don't want to name a child in your, life insurance policies, your bank accounts, none of that, please. So number 10, forgetting about pets. Now, with no plan in place for the care of your pets, they could end up spending the rest of their lives in a shelter, which would be horrible. So, think about your pets. They're a part of the family too. I know, myself included, we adopted a dog a number of years ago, and he's actually part of our plan. And I know a number of people who don't think about including their pet in their plan until they actually sit down with me and go through the questionnaire that we require people to go through, because it jogs your memory of like all the people and the things and all your loved ones that you need to account for. So think about your pets. Think about the people in your circle who you would entrust to take care of your pets. There is such a thing, there is such a tool, I should say, in estate planning known as a pet trust. So if it's something that applies to you in your situation, you could certainly consider that. It's a good way of setting aside funds for the care of this pet for the duration of their lives, and it also directs, how those monies should be spent. Number 11, not having a plan for your business. There are a number of women nowadays, especially, who are business owners, myself included. In the event of, a spouse's death, you may prefer not to carry on your late spouse's business. Conversely, if your surviving spouse, may not want to carry on yours, let's be honest. You could also prefer to have a close friend run the business, or you can arrange for the business to be sold. That's another term for that is called business succession planning. What do you want to happen to the business as do you want to retire? Do you want to sell it? So those are so many things to consider. Here we go. Now, number 12, misunderstanding probate versus non-probate assets. Now, state law controls the process for requiring whether your loved ones go through probate or not. So probate, what is it? It's a legal process that, one, it's validating the validation of a will if there is one, but it's also a legal process that involves the finding and securing of a person's assets, liquidating liabilities, paying taxes, and then distributing property, to heirs. Not a non-probate asset. What are we talking about there? It's an asset that automatically transfers to another person by way of a contract. So insurance policies, a pension, a jointly titled bank account, certain jointly titled property, and then property held in a trust. So those are examples of non-probate assets. 13, assuming your spouse will receive everything and skip probate. Laws vary, of course, from state to state. So don't assume that a surviving spouse is automatically going to receive everything. If your accounts are in your name only, and there are no, payable on death beneficiaries, no PODs, the only way to get those accounts open is to go through the probate process. So again, don't make that assumption. 14, leaving your spouse in charge of estate planning. Okay. And I've seen this even among very highly educated, professional, successful women. They leave a lot of this stuff, a lot of the estate planning to their husbands. I think it's, if I had to, guess, it's just part of our society, or patriarchal society, where we, men were historically and typically dealt with, finances and so forth. And women they were brought up to just abdicate those responsibilities to men. And like I said, among very educated, professional women, this still goes on. Stop. Take an interest in your future. The stats show that we women are outliving men by an average of about 5 years. So what happens then if your husband passes away? Don't be caught like a deer in the headlights with no idea where documents are housed, where no idea where the investments are. You don't know how much you have. You have an idea because the bills somehow always, get paid month after month, but you really have no understanding of how much is in your estate. What do you have in the bank accounts? So, what's the plan? If you become incapacitated, who's going to pay the bills when you are in the hospital? Let's say hubby's passed away, you get sick. What is the plan? So there's got to be some intentionality, some forethought as to how things are going to be managed so that you don't, swirl into chaos. So do not leave your spouse in charge of estate planning. This should be something that both of you are involved in, actively involved in. Okay. And after all of this, the mission of my firm and this show is empowering women through estate planning. So delegating that to, your spouse is certainly not a way to get you to the road to empowerment. So 15, failing to understand your rights under the elective share statute. Now, Maryland protects spouses from being disinherited by the other spouse. The rule of law called, the elective share gives the surviving spouse the right to receive a fixed amount of the deceased spouse estate. The purpose of the elective share law is to, ensure that the surviving spouse is provided for within reason for the remainder of, his or her life. So understand that. I bet a number of you weren't even aware that there was an elective share, law. So be aware of it. Ask your estate planning attorney to explain that to you if you still have questions about it, or give us a call. We're here. We're certainly here to help. Number 16, forgetting to update your estate plan. Now, it's my recommendation that you review your plans at least every 3 years. As a courtesy to our clients, every 2 years, we give a courtesy call just to, check and see whether anything has changed. That's complimentary to our client or for our clients. But at a minimum, you should always take a look at your estate plan. Take it out of, if it's in a safe or on a shelf, someplace secure, and take a look at it if the following has happened or have happened. Has there been a death in the family? Does someone suffer from a disability? Has there been a divorce? Have you moved? Distance. Is there distance now? And of course, if there are new members to the family. Let me go back for a second on the moving, because there are some folks that ask me, well, I'm planning to relocate. Do I need a, brand new estate plan? Not necessarily. What you want to do, if you know that you're going to be relocating to another state, invest in a consult with an attorney in the new state of where you're going to reside, and just have them look over your estate plan to see if everything is in line and will be honored by the authorities in that new state. So it's certainly worth your time and investment to do that. So yeah, and then the other thing, of course, is descendants. If they're new, if you're welcoming a new child into the family, if there's a new grandchild in the family, and now you want to make provisions in your estate plan for that grandchild, that's an example of when you want to take a look at your estate plan again and tweak it as needed. Remember, your estate plan is a living set of documents. It should evolve as your life situation changes. And then now we get to number 17, the last one on the list. Here we go. Not seeking help from a professional. Many women who are new to the estate planning process make the mistake of going it alone. They try to DIY it. And like I said, we covered, earlier, we talked about the elective share, statute. That's something that I'm sure that a lot of people didn't know. But if you were to consult with an estate planning attorney, certainly that's something that would have been brought to your attention, something to think about as you are creating your estate plan. We've covered today 17 mistakes made by women and how to avoid them. The thing is, we don't know what we don't know. So consult with a professional. There are a lot of resources, free resources out there. If you are new to the estate planning process, it's something that you need, but you're still unsure about some things. There are a lot of free resources out there. My website, for example, at elsawsmithlaw.com, and you see it scrolling across the bottom of the screen, has a number of free resources that really break down estate planning, what it is, how it can benefit you and those you love. So I encourage you to really invest in yourself this year in 2022 by educating yourself, because that's what I'm trying to do with not only Women Winning Wednesdays, but all the other videos that I produce is to educate. And once you are educated, then that leads to empowerment. Okay. And I want to be a resource for you to help get you across the finish line. I want to thank you for joining me on this episode of Women Winning Wednesdays. Well, some of you who are new to the program may not know that we air a show every Wednesday at 1:30 p.m. Eastern. So I invite you to join us again next week. We have our episodes include educational content like what we had today, as well as very interesting guests. And I'm excited about the guests that we have coming up during the first quarter of 2022. So stay tuned, connect with us if you need assistance with estate planning and you're in Maryland or the District of Columbia and want to have a strategy session. Give us a call, 410-995-7719. You can also schedule a consultation right online. You don't even have to pick up the phone at elsawsmithlaw.com. I'm Elsa W. Smith, your Maryland estate planning attorney, empowering women through estate planning. Have a great day, everyone. Take care.